My name is Remolla Naidoo, and I am a legal advisor at the Consumer Protection and POPI departments at SEESA Durban.
Good day. My name is Ashlin, and I am a legal advisor in the Consumer Protection and POPI department based in Durban.
So today we're going to be taking a brief look at what the consumer's rights are with regards to the goods being purchased, the services being supplied, the amounts which make up the total price, as well as what information needs to be contained on your sales record documents so that the consumer knows who the supplier is. So this information is of utmost importance with regards to the goods being purchased as well as the services being supplied. Perhaps the goods might be defective or the services rendered might not be of the correct quality, or in the manner in which a person would generally be entitled to expect. So what now? What do we do? Who do we call? The Consumer Protection Act aims at seeking to create a balance between the consumer's rights as well as the supplier's obligations. With that being said, Ashlin, can you enlighten us as to what Section 26 of the Consumer Protection Act, which deals with your sales record requirements, entails?
Sure. Section 26 of the Consumer Protection Act states that a supplier must provide a written record of each transaction to the consumer to whom any goods and services are supplied. There is no minimum sales value or a limit exemption in this regard.
So what information needs to be on these so-called sales record documents?
So at least we need to have the supplier's full name, registered business name, and VAT registration number, if any, the address of the premises at which or from which goods and services are supplied, the date in which the transaction occurred, a description or name of the goods or services rendered, the unit price, the quantity, the total price before taxes, any applicable taxes such as VAT, and the total amount inclusive of any taxes.
So what you're trying to say is that if I were to go to a shop to purchase a can of cool drink, that this information would need to be on my receipt?
Ideally, it ought to be there. But if we have a look at most points of sales as we speak, well, we call it till slips generally, that sort of sales record that we receive lacks the essence of what ought to be on that document as prescribed in Section 26 of the Act.
Okay, so what information exactly needs to be on this description? So staying with the example of the can of cool drink, does the supplier need to now specify the name or brand of that cool drink as well as the quantity and the flavor of that cool drink?
So if you look at description, obviously an abbreviation or general description would not suffice. Broad terms such as soft drink or just cool drink on its own would not be sufficient. Ideally, the brand of the good that's being sold should be on there. If it's a cool drink, for example, the flavor, whether it's Fanta, whether it's grape, should be on that sales record. The quantity as well. So if it's a 340 ml can or if it's a 500 ml buddy bottle, the whole point is the more information, the better, so that the supplier can ascertain what product was sold to the consumer in the event of a dispute or some sort of conflict.
Okay. And are there any instances where businesses would not be required to comply with the requirements under Section 26?
So there are specifically granted exemptions by the Minister of Trade and Industry. Also transactions that fall under Section 43 of the Electronic Communications and Transactions Act. Under these two circumstances, the supplier will not ordinarily need to provide a sales record to the consumer. However, under any other circumstances, the supplier ought to provide the consumer with a sales record.
Okay, so would a hawker also need to provide a sales record in terms of Section 26 when conducting a transaction?
In terms of the regulations, a hawker is exempted from furnishing the consumer with a sales record. There is another exception as well where the consumer does not necessarily want the sales record. So if the consumer refuses on his or her own that they do not want this particular sales record, then the supplier is not necessarily obligated to furnish them with one. Ideally, the consumer should take it, because in the event of a conflict or a dispute or a return, the sales record comes in handy.
Okay, and is there any other information apart from the requirements under Section 26 that needs to be included on these sales record documents?
So if you dig deeper into the Consumer Protection Act, you will come across Section 79, which basically says that a supplier must not advertise, promote, offer to supply any goods or services under any name except their full name as recorded in their ID document. Or if it's a juristic entity, the name of that closed corporation or the name of that company or partnership, so to say.
Okay, so what you're saying here is that the names of the directors of a company would need to be included on your sales record documents, and the names of the members of a closed corporation would also need to be included on those sales record documents.
Yes. So the names need to be on the sales record, but if you look further into Section 79, not only does it have to appear on a sales record, they speak about, or the Act speaks about a trade catalog, a trade circular, a business letter, an order for good, as well as a statement of account. So the names of the directors or the members of the CC, for example, needs to be on those particular documents as well.
Okay, so what do you think was the intention of the legislature with regards to requiring this information on these company documents?
It's obviously to enforce the consumer's rights. So in the event that there's a fronting company selling the goods and there's the actual company in the background who is supplying these goods, it's to eliminate any frustrations. It's to provide a consumer with sufficient detail to contact the supplier and to get the redress that that consumer requires and deserves, where there is a product that's defective or a service that's not of a particular quality and standard.
Okay, so ultimately businesses would need to ensure that their documents conform with the requirements as set out under the Consumer Protection Act. So here at SEESA, we can assist you with regards to ensuring that your documents comply with the requirements as under the Consumer Protection Act, as well as assist with regards to any disputes between consumers and suppliers. Should you require any further information, please contact us either by going onto our website. Alternatively, you can contact your nearest SEESA branch.